Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer your questions. Tonight, I have a great topic to talk to you about tonight. It's going to be the fiance visa versus the spouse visa. Which one should you choose? But keep in mind that I am here to answer your immigration questions, so feel free to put your questions in the comments at any time, and I will answer your questions in between the topic that I'm talking about tonight. So let us go forward with that. Let me remind you, I'm both on YouTube and I'm both on TikTok tonight. Also, after this, I will be hopping on over to Instagram. So you can continue to ask your questions on Instagram and Facebook. I am ST Law Office, the name of the law firm, on Facebook, and I'm the immigration attorney on Instagram, same as here. Now, the fiance visa versus the spouse visa, usually you're deciding this at a point where you're not yet married and you're trying to decide whether it is better to pursue the fiance visa, to bring your fiance to the United States to start to live with you, or whether you should just go ahead and get married in the country of your immigrant significant other and then move forward with the spouse visa. Which one is the better one? You're gonna hear me say multiple times that, hi there, Stockholm. You're gonna hear me say multiple times that it's going to come down to your particular circumstances, but I'm gonna talk about some considerations when you are thinking about choosing the fiance visa versus the spouse visa. First of all, it is always best to get legal advice before you do anything, before you schedule any kinds of, before you submit any types of applications. Make sure you schedule a consultation with an immigration attorney who can help you through your particular circumstances. But I'm going to give you some general information here. Now, at the point where you become married, hi there, Vibes Cartel Vine, nice to see you. At the point where you are officially, you are now married, then at that point, it's too late to apply for the fiance visa because you are already married. So at that point, you will not be applying for the fiance visa. So the best time to consider which one would be best is before you get married. Now, when you're trying to choose between the fiance visa and the spouse visa, you're going to think about these considerations. If you're here in the United States and you want your significant other to be with you, you do intend to spend the rest of your life with them at some point in the future, but you don't necessarily want to just jump and get married. You want time to spend with your fiance. You want to be able to try out life, settle in the United States. You may want your relative to meet your relatives to meet your immigrant fiance first in the United States. You may want to have a big wedding in the United States. Maybe your first choice isn't to have a wedding in the foreign country, but to have it in the United States. If these are your consideration, these are what you're concerned about, these are non-negotiable factors in your decision making process, then at that point, you're going to focus on getting the fiance visa. Now, keep in mind, that's where you need to get legal advice, though. This is just a hint that maybe the fiance visa is better for you, but you want to make sure to consider all aspects of your circumstances before coming to a final decision in a personal consultation. I'm going to pause to answer questions here. So hi there, Danmi, nice to see you. So let's see, a friend of mine is being emotionally abused by her LPR parent. She's 40, can she file for VAWA? So great questions. Unfortunately not. This is for this is for individuals who were abused as minors. So if they were under 18, they have up until they're under 20, until they're 21 to apply for this, and in some cases, until they're 25 to apply for this. Once they get to 25, it's too late. But once at the point where she's 40 years old, she would not be able to apply for VAWA. Honey Bun Sunshine 876, and love the area code. Thank you for sharing the live. So I got a question for you. My wife is not a citizen, but she has a green card residence. Will I get the 2-year? No, at the point, that is not the determining factor of getting the 2-year, to get the 2-year permanent resident. It's going to be whether you have been married for less than 2 years at the time that you're approved for permanent residence. Now, keep in mind, Danmi, if your wife is not a citizen and she's a legal permanent resident, if you're in the United States and you're already out of status, you want to carefully consider your situation. Make sure you're on the right path and you're following the right process. Kerry Harriot, you're welcome. Now, I've just mentioned some of the considerations and some of maybe the benefits of applying for the fiance visa. Let's talk about the spouse visa for a minute. Now, the point that you do say you're trying to choose between bringing your fiance here first and then getting married, or getting married first. At the point that you do get married, it's too late to consider the fiance visa. Thanks, Vibes Cartel, for sharing the live. And thanks, Ashy Boo Edwards, for sharing the live. I appreciate it. Now, with the spouse immigrant visa, if you are trying to decide between the two, the benefit of getting married first is that you will jump straight into the immigrant visa process. That means that your spouse will be able to, once they go to the interview, they attend the interview and get approved for the immigrant visa. Once they land in the United States with that immigrant visa, they will become a permanent resident upon walking out of the airport or the port of entry where they came into the United States. That's the benefit. Now, with both the fiance visa and the spouse visa, there is an irregularity now with processing time. Some embassies are only doing it on a limited basis. For example, the K1s are at some embassies they're being issued on a limited basis, and in some cases they are it's the same timeline. You could expect about 1.5 years for the K1. The K1 is the fiance visa, by the way. And then the spouse immigrant visa, you could be looking at anywhere from 18 months to 24 months. I am seeing it trending more towards the 2-year processing time, though. All right, let me go on to questions again. My husband is a permanent resident and filed for I-130 in November 2020, but no approval update as of yet. So yeah, unfortunately, Honey Bun Sunshine, it's taking more than 1 year to get approvals on I-130. So it could take anywhere from 9 months to even 18 months. Now, keep in mind also that the estimates that I'm giving you, these are just estimates based on my experience. It is not down to a science that is going to happen in your case. That's where, if you have filed it, you need to check with the USCIS, make sure everything is going okay on your particular case. Okay, so Pre-231. So my uncle has a lawyer. He's been here 30 years, working, paying taxes, and still waiting for his interview. Yeah, so he should defer to his attorney. But yeah, the processing times are long. I'm married for 2 years and wife filed for divorce. How will that affect me getting the 10 years? So Lion Ja, it could affect you if you don't apply for a waiver. So if you're applying for the 2-year to the 10-year, you're going from the 2-year to the 10-year, you want to make sure that if you're getting a divorce that you're doing it properly, because if you don't, you're going to get denied, and then the process is going to be a lot more complicated for you. So make sure that you schedule a consultation, get representation through your process. But at this point, if your wife and you get divorced, you'll need to submit a divorce waiver. And also, if there is some mistreatment or abuse in the marriage, then you could apply for a waiver based on that. And also, you can show that you'll experience extreme hardship if you lose your status. Then that's another way. So you should definitely go ahead and schedule a consultation. Can't stress that enough, that the consequences of not following through with this process properly is going to lead you to get a notice to appear in immigration court for deportation if you don't do this properly. So let's see, how do we reach out to the USCIS to find out what's happening with the case? So honey bun sunshine, if you go to uscis.gov, so the same thing that you typed .gov, you'll see the contact number and you can contact them that way. Can I use my nursing license to get my green card? It may be a possibility. I would have to determine, I would have to determine the extent of your qualifications. So for example, if you are at the top of your field and you meet certain criteria, that may be the national interest waiver, or it could even be the extraordinary ability green card. But I would have to first, I don't want to say that you can't until I absolutely know what your qualifications are. In the case that you have an employer, then if they agree to also sponsor you, that could be a way as well. Do you know any good traffic lawyer? No. So I don't, Big Body Zati. I am a U.S. immigration attorney, so I'm not a Jamaican attorney. I am Jamaican, but I'm a U.S. immigration attorney. So I'm a lawyer in the United States. What is the waiting time again if my husband is a green card holder again? So right now, Ashibu Edwards, I'm seeing about 18 to 24 months, but it doesn't mean that that's going to be the case for you. So I did the paperwork and sent it in and got a 2 years extension. So that's great. But if you don't do the waiver, Lion Jack, that's one of the major mistakes that I see with this type of application. Is a lot of people think you just submit the application. If you and your wife are separated, you just go ahead, you submit the application, and then you will automatically get the tenure. You have to proactively submit the right documentation to get your tenure. At the point that you and your wife are separated or you're going through a divorce, you definitely need to submit that waiver. While you have the 2 year extension, that's great. In order to get the approved for the tenure, you'll definitely have to make sure that you follow through properly, or you are going to have a nasty surprise at the end of the process. So, and I've seen this mistake before. So Lion JA, just make sure you're doing it properly. I don't know your situation. I'm not your lawyer. I haven't reviewed your paperwork. I haven't reviewed what you've done. But what I can say is be very cautious about, don't underestimate the process. Make sure that you understand all the requirements and get the right legal assistance to avoid getting any kind of nasty surprises towards the end of your process. Can we still get EAD while waiting on hardship waiver for a marriage-based case? So Pappy SD, I'm not sure if you're going through adjustment of status and you have submitted a waiver at that point, then you would be able to get the adjustment of, you would be able to get an employment authorization. But I don't know what kind of application you've submitted, and I wouldn't be able to tell you. But during adjustment of status, you can get the employment authorization. So I'm going to continue my topic, and then you can continue putting your questions in the comments. So I have been talking about the fiancé visa versus the spouse visa, and it's really the one that's going to be better is going to depend on what works for you. Do you want to just jump into a marriage? Are you ready for marriage, or do you want to try out life with your fiance in the United States before? But here's a very, very, very important consideration now, is that only U.S. citizens can apply for the fiancé visa. Legal permanent residents cannot apply for their fiancé to get a visa to come to the United States. So that definitely takes out a chunk of individuals who want to bring their significant other to the United States. If you are a U.S. citizen, then you have a choice between the fiancé visa or getting married and bringing your spouse here on the immigrant visa. However, if you are a resident, a legal permanent resident, at that point, your only choice would be to bring your spouse to the United States. So here are the requirements for the fiancé visa. At the point that you're deciding whether you should go ahead and apply for the fiancé visa or get married, you'll have to show that you do intend to get married once your fiancé gets to the United States. Your fiancé would get a 90-day visa. That means that you are when you get the 90-day visa, you will have within that period to get married, and then after that you will be able to file for adjustment of status based on the marriage. You would not have to file an I-130 petition, but you could go ahead and file adjustment of status, stay here, and get permanent residence. You do have to show that you have met each other physically within the most recent 2 years before you applied for this. Now, if you have not met each other and you have not met each other because of certain traditions, cultural traditions or religious traditions, or because there are extraordinary circumstances involved that prevented you from meeting each other. For example, if your fiance is living in a country with conflict, or you would be persecuted in the country, those could be examples of exceptional circumstances that prevented you from seeing each other physically within the most recent 2 years. And you could bypass the physical requirement there, but generally it is still required. And then, of course, the U.S. petitioner has to be a U.S. citizen. All right, so received a NOID and filed a hardship waiver. So the question is if we still get the EAD. So the NOID does not mean that you have been notice of intent to deny, PAPI SD. If you have an adjustment of status application pending and they finally deny your adjustment of status application, then the employment authorization that's linked to that adjustment of status is going to not be valid anymore. And at that point, you will not be able to apply unless you reapply for adjustment of status. Now, PAPI SD, your situation is complex because you've already received a notice of intent to deny. That's not an official denial, but they're giving you an opportunity to respond, usually within 30 days. Now there's an additional 60 days that's added on top of that to respond, to change their minds as to why you should not be denied, or to make a legal argument here. So you need to get legal advice if you're not already represented. And then keep in mind that if you already have an attorney, you should always defer to your attorney. This is alive. I'm not giving personal legal advice here. I'm giving general information. And so you should not be acting on this information until you get personal legal advice. So if you are not already represented by attorney, you should get legal representation, because it is getting into complex territory, and you want to be sure that you avoid a denial. So that notice of intent to deny, you could avoid a final denial, but I don't know what's in it. I don't know the basis of the NOID. I don't know what your situation is, or why, when, at what point you applied for the hardship waiver. But you need to act quickly. How a child have legal rights through SIJS. So the SIJS is a special immigrant juvenile status, and it is for children who have come to the United States, and they came to the United States so they were either abandoned by one or both of their parents, or abused or mistreated in some way. And so they are without their guardianship in the United States. And so when they first go through the court system, they usually have to do that. It's really state by state. But most courts are going to designate them a dependent of the court when they're under 18. So it's very important that that is done quickly, especially if they're approaching 18. At the point that they have been granted this designation, then you can take the court order and file for the juvenile status. And that would allow them to eventually get permanent residence in the United States. So that is how, children, for example, unaccompanied minors would be a group of individuals that could get SIJS. But not just unaccompanied minors. One example I can use is if, for example, an undocumented child is here with their relative, another relative, an aunt, a cousin, an acquaintance, and their parents left them, abandoned them, or are not taking them back. This could be a way for that child to get status. And as long as they get that they're designated dependents of the court before the age of 18, then and they apply for status before they turn 21, this is very much a possibility. So Bright Sky, this is something I can help clients with. You can get in touch with the office and schedule a consultation. Candy Girl TNT, thanks for sharing the live. If a non-citizen marries a green card holder citizen, how long will it take to file for a child? So it's going to depend. If the child is under 21 and unmarried, they're looking at about 18 to 24 months. But keep in mind that it's not down to a science. It really comes down to what the case looks like, what's involved. Will there be a waiver involved to make the process longer? So but generally you're looking at about 18 to 24 months. But that's not a guarantee that that's going to happen in your case. Okay, so I-485 status is showing case must be reviewed. It just means that they're reviewing your case. If you're really concerned about what's going on, you should contact them, because I'm not the attorney. I'm not representing you. And so I wouldn't be able to tell you what's going on in your particular case, but usually it's not anything alarming that they're reviewing your case. But I don't know if have you been approved and then now they're saying they must review it? If that's the case, then maybe that's something to be concerned about. But if you have just filed it and it's been pending, and they say it must be reviewed, it's probably in the queue waiting to be reviewed. All right, so that is it. That's going to be it for me today. I am going to be back tomorrow at around 9 p.m. Eastern time to continue to take your questions and also to bring a great topic to you. I'm not going to be done for the night though. I'm actually heading on over to Instagram, where I will continue to take questions, and then I will bring a topic to talk about there. I am Christina Williams on YouTube. Go ahead, put your question in the comments. I'll gladly answer. And since I see some more questions coming in, I'm gonna just answer. So Christina, you go ahead, put your question in before I head out. If I'm the patient of a 3-year-old, parent of a 3-year-old US citizen, what are my chances of getting a green card? So you'll likely have to wait until your child is 21 before they can file for you. And so I'm going to take a few more questions. You can put those questions in the comments. While I wait for your questions, I am going to tell you how to schedule a consultation. Because remember, the information that I've given you tonight is not personal legal advice, it's general information. So you should always schedule a personal consultation with a qualified U.S. immigration attorney to make sure that you get the guidance, the representation you need to go in the right direction. In your case, I am that U.S. immigration attorney. I'm experienced in my field. And so I help my clients in a broad range of areas, and I'd be able to help you in your situation. But we'll need to talk in a consultation for me to fully advise you about your options. You can do that by going to the link in my bio. And when you go there, when you click on the link, you're going to see various options. You're going to see a button to schedule your own consultation. You're going to see a button to the website. Go ahead, click on any one of those options that suits your needs. When you go to the website, there is a phone number, there is the contact form, and there's online chat. The scheduling coordinator is available up until 11 p.m. Eastern time tonight to take your call and help you to schedule your consultation, or you could go ahead and schedule your own consultation. So I don't see any more questions coming in. Okay, I see Christina. If my partner has 3 kids and owes back taxes, is it okay to marry him? Would that affect my option? Is apply for status if we are married? He owes $10,000. So it depends. Now, owing taxes does not necessarily disqualify him as your petitioner. However, if he doesn't file his taxes, that may be a problem in regards to the affidavit of support. So you want to make sure that that he files his taxes. But I have represented clients who have owed taxes and they've not had any issues petitioning their spouse. But where they want to see is that you have filed your taxes. But Christina, keep in mind, that is not an endorsement to go and just jump into the marriage without fully considering, because I haven't evaluated your full circumstances. I haven't evaluated all of your, all of the qualifications, all of the factors involved. And that's where it's very important to schedule a consultation. You can do that by going to ST Law Office and or calling 561-405-4889 to go ahead and schedule your consultation. So you can go ahead and do that, and you will be able to schedule a consultation with me. But I owing taxes alone isn't necessarily going to disqualify you from applying. All right, thanks so much for your questions, everyone. I am going to be heading out now. I will see you tomorrow at 9 p.m. Eastern time. If you don't see me here, you can always check Instagram, The Immigration Attorney, or ST Law Office at 9:30 p.m. Eastern time. Have a good night, everyone. Also, you said child support. So Christina, child support, the same thing. So if they owe child support, yes, they owe child support, but they don't usually ask for child support. What they do ask is the number of dependents in the household, and that's going to count against their income. But they don't usually ask for child support, evidence of child support. But just make sure that you do your due diligence to schedule a consultation, and you can do that by going to the website or calling 561-405-4889. All right, have a good night, everyone. See you tomorrow. Bye-bye.